Good morning, everyone. Welcome to today's webinar. My name is Chris Justice, and I'm joined here again with my colleague, Kimberly Smith. And today we're here to talk to you guys about constructive dismissal, what it is, what some examples of it are, what the court's comments have been in regards to constructive dismissal, as well as some general considerations to take into account for both employers and employees who are faced with this issue. So from the outset, I'll give a bit of a general overview of the term itself before handing it off to my colleague who will go through the actual test from the court's perspective. So constructive dismissal is essentially when there has been a fundamental or significant change to the terms of an employee's contract that they do not necessarily agree with, but that's unilaterally imposed upon them by the employer. So a fundamental or significant change. And that can be in terms of what's actually written down in the contract of employment, or it could be an implied term that's not necessarily written down, but implied as a part of every contract. One example being to treat all your employees with civility, dignity, respect. So for example, an allegation of harassment or discrimination could constitute a change of an implied term or a breach of an implied term. Whereas, say, a reduction in salary or the removal of some duties could be something that's actually said in the contract that ends up getting changed. But either way, it has to be significant and unilaterally imposed, and that is in essence what constructive dismissal is all about. So with that said, I'll turn it over to Kimberly.
Thanks, Chris. Okay, so I'm going to go over a Supreme Court case where they outlined the test for constructive dismissal, and that was a 2015 case called Potter versus New Brunswick Legal Aid Services Commission. Now, there are two tests. One or the other can be satisfied in order to find constructive dismissal. So under the first test, that involves identifying an express or an implied contractual term that has been unilaterally breached. I believe Chris just sort of summarized that. Now, it is an objective test. Now, the other issue with this part of the test, if the authority to make the change either exists in the contract or the employee consents to it, then there's no breach. Because as mentioned, the breach has to be unilateral, as in it's been handed down by the employer without the consent of the employee. So if the employee consents, then there's no breach. Now, once there has been found to be a breach, the next part of the test is to determine whether the breach was sufficiently serious to constitute constructive dismissal. Now, this is a matter of degree. Not all changes are equal. So typically, the types of changes that you'll find will result in a finding of constructive dismissal are issues relating to compensation, work assignments, the place or location of location of work. Now, that's one test. The other test that can lead to a finding of constructive dismissal is looking at the conduct of the employer in light of all the circumstances and determining whether a reasonable person would conclude that the employer no longer intended to be bound by the terms of the contract. So with this test, the employee doesn't have to point to a single breach in order to find constructive dismissal, but rather it's where the course of conduct cumulatively amounts to an actual breach. So those are the two tests outlined by the Supreme Court to determine whether or not constructive dismissal has been made out. One point that Potter makes as well is that damages for constructive dismissal, they are the same as damages for wrongful dismissal. So at the end of termination, as far as being entitled to reasonable notice, damages for that will be calculated and determined in the same way as a wrongful dismissal.
And it should also be noted that even though a change to the terms of an employee's contract may be done in good faith or for legitimate business reasons, that in and of itself would not absolve the employer from liability. Again, the focus is on just the fact of whether or not there was in fact a significant change that was unilaterally imposed. So just something to keep in mind for employers. But with that said, we'll now get into some actual examples. I've sort of touched on a couple from the outset, but some specific examples of constructive dismissal and sort of how the court responded to those particular allegations.
Okay, so I'm going to go over some cases that deal with, as Chris mentioned, different examples of constructive dismissal. So the first example is a demotion. So this case I'm going to discuss is an Ontario Court of Appeal case from 2012, and it involves demotion. The salary remains the same. So in this case, a plaintiff who's a senior manager, there was a complaint by some of his subordinates about his management style. Now, the bank did not launch an investigation. The bank was the employer and refused to provide the plaintiff with particulars of these complaints. So they served the plaintiff with a disciplinary note advising that he was being demoted to one of two lesser positions. And in these lesser positions, he would not have any supervisory role. So no one would be reporting to him. The compensation was to remain the same. However, the plaintiff took the position that he had been constructively dismissed, which, as we'll discuss later on, is a very high-risk decision to make. And the courts rejected the bank's position that he should have remained with the bank to mitigate. The reason being is that the court accepted the plaintiff's argument that to return to work to mitigate in one of those lesser positions would be humiliating. Now, the next example I'm going to discuss has to do with an actual reduction in compensation. Now, there's no hard line as to how much of a reduction is going to make out a claim for constructive dismissal. I would say, generally speaking, an employer should take some care when they're trying to implement decreases of greater than 10%, leaning into the 15% range. Now, that being said, the case I'm going to discuss is an Ontario Court of Appeal case. And in this case, it involved a CEO, and it was not his base salary. It was a one-time bonus that he was not granted. And he took the position that the refusal to give him this one-time bonus constituted constructive dismissal. The court disagreed. The terms and conditions remained in place, and the employee they determined was sophisticated and had other options of pursuing this dispute over the bonus, such as arbitration. He could have proposed arbitration versus just quitting his job. Now, it should be noted that, generally speaking, there's more flexibility in terms of the variable component of a compensation package versus a base salary. So what I mean is that courts are going to look more closely at changes to base salary versus components that are subject to change.
Yeah, it can definitely be difficult to determine whether and to what extent there's been a constructive dismissal if what's being impacted is an aspect of compensation that's not exactly clear as say, base salary, or that's contingent on some things, or that may not be paid until a later date, or in the case of a benefit that gets removed, another question would be trying to value the loss of that benefit. So it's not always clear, and all the more reason why both employers and employees should seek legal advice before sort of taking any further action. But yeah, so it can really depend also on the facts of each case, the sophistication of the parties, what's included in the contract. So again, case-by-case basis, and all the more reason to seek legal counsel.
Okay, so the next example I'm going to look at is that of geographic location. Now, in this case, it involved a 59-year-old manager of a consulting who worked in consulting services for 22 years. And part of the work arrangement was that the consultant was able to work from home 3 out of 5 days a week. Now, the consultant worked 110 kilometers away from work. And for no reason, out of the blue, the employer decided that the employee was no longer entitled to work from home and insisted that instead of being able to work 3 days out of 5 from home, they needed to be in the physical office location every day, 5 days a week. Now that commute is 110 kilometers one way, so 220 round trip, and the court agreed with the plaintiff that this constituted constructive dismissal, and that was the finding there. So there was also another case. Now this dealt with a relocation of an equity trader's position from Vancouver to San Francisco. Now there was no express or implied contractual term that would allow for such a transfer. And the court rejected the employer's argument that, well, this is a multinational company with increasingly international nature of their business. And in order to reduce operating costs and increase opportunities for revenue, the request of the employee to move from Vancouver to San Francisco was reasonable. The court disagreed. So here, they also found a finding of constructive dismissal on the basis of geographic location. So the next sort of ground that I'm going to look at is temporary layoff. When does a temporary layoff constitute a constructive dismissal? Now, in this case, it was in the automotive industry, and there was no formal contract between the parties, but the evidence showed that layoffs are common practice in the temporary layoffs anyhow are common practice in the automotive industry. And so for this reason, an implied term was found in the contract that permitted temporary layoffs. Now, the issue here was that the layoff was indefinite, and there was no implied term that allowed indefinite layoffs, and an indefinite layoff was found to be a fundamental breach.
Yeah, just on the point about layoffs, it's a bit of an interesting one because, as many employers may be aware, the Employment Standards Act, which is the legislation governing provincially regulated employers, actually sets out or has provisions dealing with layoffs, temporary layoffs, and according to the ESA, would allow an employer to lay an employee off for up to 13 weeks without having to provide any form of payment or benefit, and up to 35 weeks in a given 52-week period, provided beyond the 13-week period some sort of benefits provided. So you could look at the ESA and think, as an employer, you're permitted to temporarily lay an employee off. However, it's a bit of a strange one in that the common law or judge-made law has sort of the opposite to say, which is to say that it's in fact a constructive dismissal, notwithstanding the language in the ESA. So it's definitely something, layoffs that would necessitate legal counsel, but it is an example of where the common law would actually override the statute. Now, there are, as Kim mentioned, cases where there is a particular industry or line of work in which layoffs are much more common. Construction could be another example. And in those cases, it's more likely that there is an implied duty or term, I should say, allowing an employer to lay an employee off temporarily. But even still, it's not a guarantee. But aside from those industries, if it's not something that's common, and again, despite the language in the statute, and in the absence of a contract that allows or speaks to an employer's ability to lay that employee off, by doing so, even in compliance with the ESA, would still arguably amount to a constructive dismissal at law. So employers just should not assume that because what's in the ESA, and again, this is sort of an unusual issue with layoffs, but shouldn't assume that just because it's in there that they're allowed to do that and that there's no potential ramifications. So that's just a slight aside I wanted to mention on the issue of layoffs.
Yeah, thanks for that, Chris. Okay, so the final sort of grounds for a finding of constructive dismissal is the issue of suspensions. Now, this is a 2018 Ontario Court of Appeal case. What happens when an employee is suspended for administrative reasons? When will the court determine that, it's in fact a termination, a constructive dismissal? Now, the court has determined that an employer has the power to suspend employees for administrative reasons. And the Supreme Court of Canada has confirmed that this power exists. So long as the suspension is necessary to protect a legitimate business reason, the employer is acting in good faith and fairly, and the suspension must be for a relatively short time period and a fixed term. So there are some similarities here to temporary layoff in the sense that, it can't be indefinite, right? There needs to be some sort of, restraint on the time frame. Now, that what I just went through, though, when I was referring to administrative suspensions with pay. Now, administrative suspensions without pay have to be or should be in very rare circumstances, which is understandable. Part of the employment contract involves paying salaried employees as part of the agreement. Now, in order to impose an administrative suspension without pay, an employer has to prove that the suspension is justified, that there is a basis in the employment contract or the employee's policies for unpaid suspension, and that the decision to suspend without pay is reasonable and justified.
So, oh, sorry, go ahead.
Yeah, I was just going to say, so again, we see here again the need for, a basis in employment contracts. This is a very high threshold for unpaid administrative suspension.
Yeah, so if it's without pay, it's going to be very difficult for an employer to make it out. And even if it's with pay, as Kim mentioned, a key focus has to be on the duration of the suspension and the actual rationale behind it. So before doing that, even if you feel it's necessary, let's say, for instance, you're suspending someone with or without pay pending the result of an investigation that's being done in the workplace, most definitely, again, contact legal counsel to get some advice, because that could be a minefield that you otherwise would be entering into. I'll add one more example to the list, and that has to do with performance improvement plans. So if you've got an employee who you believe their performance is not up to par, first of all, you should engage in a general progressive disciplinary structure. You should sort of take certain steps before placing an employee on a performance improvement plan or a PIP, because that should be seen not necessarily as a last measure, but near the end of it. So sometimes employers get a bit too hasty in deciding to put an employee onto a PIP, and if for whatever reason the employee disagrees as to the legitimacy of the PIP, that they should be on it. Perhaps they're raising issue with the fact that these concerns were not raised before, or that they weren't notified that if these issues continue that they could be subject to a PIP. That in and of itself can also trigger a constructive dismissal. So again, as an employer, something you want to be aware of, and make sure you take all the right steps before doing that, which first involve contacting the lawyer. But with that said, I'll turn it back over to Kim. She'll talk briefly about an employee's options when they're faced with the issue of a constructive dismissal.
Okay, so there are 3 options that an employee can exercise. The first is the employee can accept the changes, no matter how severe they are. The acceptance of these changes can be through implicit insinuation or through explicit, clear-cut demeanor, or just through outright acceptance. The other option available to employee is, in some instances, you can let your employer know that you do not accept the changes made to your employment contract. Now, this can occur, for example, if changes are made to your compensation. In this case, if an employer fails to respond to you, they will be found to have implicitly accepted your argument or your protest. And the final option is you can quit. Now, if the changes in your contract make it impossible for you to work, and leave you feeling, helpless, then you can end your employment and then afterwards claim, well, you can leave your employment, I should say, and then afterwards claim constructive dismissal as the reason.
So that brings me to the issue of condonement. So I guess at what point, from an employee's perspective, should you sort of make a decision? Because depending on the change that's happening to the terms of your employment, the courts will say that you need to take action fairly swiftly. Now, there may be instances where there's a change to the terms of your employment, but you're not quite sure of the full extent to which it'll impact the relationship. So one example, again, could be that your employer advises you that effective somewhere down the road, a particular bonus aspect is going to be removed and modified, or a particular benefit is going to be taken away and replaced with another, and you're not entirely sure whether the replacement option is going to be better or worse. And sometimes it takes time to actually go through that process to determine whether or not you actually suffer loss. So it's in those types of cases where an employee might be able to get away with waiting a bit longer to fully realize the effects of the change. But generally speaking, you know, as far as it relates to just a more straight up reduction in salary or a change in location, you know, timing is of the essence, because if an employee waits too long, and that could be a matter of weeks or a couple months or a few months, and then they decide to assert constructive dismissal, a court could view the fact that they sort of remained there and waited a bit of time and just continued to be employed as that employee condoning the change, which sort of raises an issue for employees, because on one hand, if they're not accepting of the change and they want to leave, they're fully able to do so, but then they risk possibly not making out the claim for constructive dismissal. They risk having to go through litigation, possibly, which takes a long time. You know, and then on the other hand, if they wait to sort of make a decision, and maybe one that's more fully informed, they just risk sort of a court viewing them as having condoned the change. So it can definitely be an issue for employees, and it's all the more reason why, if you're an employee and you feel like you are being subjected to a change that would amount to a constructive dismissal, do seek a lawyer, because action will likely need to be taken sooner rather than later. Another point is, as an employee, you want to document your concerns. So Kim mentioned that you can accept, reject, or sort of continue there but reject. You know, that's going to involve you being clear with the employer as far as how you view the change and what you plan to do. If you plan on sticking it out a bit, but you want to make the point of saying that you're not in agreement with the change, you need to document those concerns, because you're going to be otherwise faced in sort of a he said, she said battle, and it's going to be much more difficult to prove that you raised this as an issue and that it, notwithstanding, wasn't addressed by the employer. So frankly, whether you're an employer or an employee, it is always beneficial to document things that go on, steps that are taken, should there be any future litigation or issues that arise down the road. So with that said, I'll now transition a bit into some other practical considerations for litigating over constructive dismissal. Kim mentioned before, and I might have touched on it as well, that when it comes to constructive dismissal, the ultimate standard is going to be the reasonable person. So what would a reasonable person do in your circumstances, and how would they react? And as much as an employee might like to think that, you know, everyone would react in the same way, it's nonetheless a fairly high threshold in terms of what's reasonable. So don't assume that just because subjectively you're feeling like the work environment's toxic, or you believe that the change is significant, that it in fact would be deemed to be so by a court. Again, that's kind of where lawyers come in to advise more on that standard. But you want to make sure that objectively speaking, it's something that would be widely viewed by other employees as well. Of course, the other issue, and I sort of touched on this, is that if you decide to litigate or pursue an action regarding constructive dismissal, that as an employee, you really need to be sure that the claim is a fairly strong one. Again, that will involve documenting everything that's done. But you, in litigating matter, it's almost an all or nothing proposition in the sense that you either deem to have been constructively dismissed and therefore or owe damages that might be in line with what would happen if you were let go by an employer. Or if that's not made out, then a court would likely decide that you've resigned, in which case you're entitled to nothing, depending on the wording of your contract. So again, just all the more reason for an employee to ensure that they have a very strong case, that from an objective standard, it's strong before taking that step. The other thing too is that a court could decide to recall you back to work after you refuse the change, or say that they messed up. And so issues of mitigation can also become relevant. And for that, I will turn it over to Kim, who will talk to you about mitigation.
Okay. So mitigation. Now, as we said, constructive dismissal, it's treated the same as a wrongful dismissal or termination, essentially. And upon termination in a wrongful dismissal case, you have, as an employee, a duty to mitigate. Now, this may involve returning, as Chris mentioned, to your employer's establishment, even if it's not necessarily in the same position, depending on the circumstances. So, in 2008 Supreme Court case, the court states that where the employer offers the employee a chance to mitigate damages by returning to work for him or her, the central issue is whether a reasonable person would accept such an opportunity. Now, where the salary offered is the same, where the conditions are not substantially different, or the work demeaning, and where the personal relationships involved are not acrimonious, it's going to be difficult for an employee to argue that a reasonable person would not return to such an environment. Now, while a reasonable offer of reemployment should be accepted, and this essential feature of the reasonable analysis is that the duty to mitigate should not drive an employee to accept reemployment in an atmosphere of hostility, embarrassment, or humiliation. Now, so there was a recent Superior Court case, Gent versus Strone, and in that case, the plaintiff, Mr. Gent, his own evidence demonstrated that he had no issues with his superiors. He had been temporarily laid off and recalled to work, I should add. He had no issues with his superiors, and he was, he even said that it was a great place to work and that he enjoyed his time there. And moreover, counsel for his employer in the recall letter guaranteed that the plaintiff would not be treated any differently and that there would be no reprisals. So in that case, the court found that Mr. Gent, he failed to mitigate by not accepting reemployment with his employer when it was reasonable to do so in those circumstances. So again, it's always going to be a reasonability test. What's reasonable in the circumstances?
Yeah, so again, as an employee, don't assume that just because there's been a change and that just because you take offense to the change or personally and subjectively feel humiliated or embarrassed by the change, that if the employer then goes back and says, oops, sorry, like we'll have you back, old terms as you know them, that in some way means that you're not obligated to return. Again, it's really reserved, as Kim said, for the most or the more humiliating and embarrassing situations, or where the work environment has just become so toxic that an objective, reasonable person would not return to that environment. So obviously a clear example would be if there was constructive dismissal on the basis of being faced with issues of sexual harassment or discrimination. That's very different than if the constructive dismissal has to do with something more minor, maybe a change in location that the employer essentially reneges on. That may not necessarily allow you to refuse the recall to work. So, and also as an employee, don't think that just because you sue the employer for constructive dismissal following leaving after the change, that the fact that a lawsuit's going on is going to also make it unreasonable for you to return to work. It's from what I know, a factor to be considered, but in and of itself is not going to be enough to absolve an employee of the risk that they face in refusing to do so. Aside from your former employer recalling you back under the old terms, notwithstanding the fact that they changed them before, another issue with respect to mitigation just could be that if you quit as a result of a constructive dismissal but nonetheless find new work, much like if you're terminated and do so, that could drastically affect your constructive dismissal claim. So unlike a termination where all you have to do in a more of a straight up case is decide whether or not the notice period is reasonable. In a constructive dismissal, you have to first prove constructive dismissal and then what damages flow from that. And so again, whether it's your employer recalling you back or a new employer hiring you, that could potentially impact the value of the claim and make it less advisable to pursue litigation over that matter. But with all that said, we'll conclude with just some general tips for both employers and employees. I mean, throughout this webinar, we've given a number, and I may be repeating myself, but the most important thing, of course, regardless of who you are, is before any actions are taken, especially given the potential consequence of those actions, do seek legal counsel. As far as the employers are concerned, having a good contract that actually refers to constructive dismissal, to the extent of sort of reserving the right to change duties or terms of employment, have it not constitute a constructive dismissal, would be advisable. Tying that to a termination clause that's otherwise enforceable to include instances of constructive dismissal would also be something advisable. So it just benefits employers to sort of clarify that in the contract going into it. And then on the flip side, employees, if you're presented with contracts that have language to that effect, or just generally speaking, it's always recommended to consult with a lawyer to review the contract, because it's possible that some changes, modifications can be made going into the relationship that will be beneficial for you on the way out. And as well, employers should consider when they are making changes, even if it, again, is for a legitimate business reason, giving notice to employees. So if you know a change is going to happen and you can give the employee a certain amount of notice ahead of time to say, look, say for instance, 6 months from now, we're going to be requiring that you travel another 30 minutes one way to work, at least by giving that employee the notice ahead of time, it'll give them the opportunity to consider whether or not they want to agree to that change. And then if they don't, that period of time can also be used by them to seek other forms of employment that would be comparable to the original set of terms. So much like a termination where you have the option of giving notice or pay in lieu of notice, because the same sort of entitlements would flow from a constructive dismissal, sometimes giving employees notice ahead of time will essentially eliminate any claim they may have. Now that employee may use up all that time and then assert a constructive dismissal at the end, but as an employer, you're able to say that you gave them, sufficient notice, and that if they weren't agreeing to that, that they had time to look elsewhere, rather than simply saying, effective tomorrow, we're going to have you, commute another 110 kilometers one way. Very big differences, and it could just be a way as an employer to avoid the risk of a constructive dismissal or having to pay out monies by giving them that notice. And I mentioned this before, but as far as employees are concerned, when it comes to constructive dismissals, just make sure that you document your concerns, and so that you never know what's going to happen down the road, but so that you can use that as sort of evidence and ammunition in the event that you do have a viable constructive dismissal claim. So with that said, that concludes today's webinar on constructive dismissals. We are happy to take questions after if you have any. And if you'd like to suggest a topic for next webinar from us, you can email us, and the email address is socialmedia@macdonaldassociates.ca. So again, if you have any topics, we'd be happy to hear them, and perhaps next webinar we'll be discussing them. Thank you very much, and have a great day.